Hello and welcome to Legalese. My name is Vincent Perryman and I am a local attorney with the law offices of J. Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show covers child custody. With us now is attorney Jason Allen of the law offices of J. Vincent Perryman. Jason, thanks for joining us today. You head the family law section of our firm, so a big topic that always comes up in anytime there's kids in a divorce or kids born out of wedlock is child custody and how all that works. And it's one of the, this time of year with school starting back and things of that nature, I know we get a lot of calls with questions about child custody, what can be done, what can't be done. So where do you think we should begin with that broad topic?
Well, I think you would start with an initial custody determination. Obviously, custody is something that is subject to be modified at any point, but there's an initial custody determination that's made by a court when there's a divorce or when the court simply hasn't had those parties before to determine who should have custody. And in essence, when you're making the initial custody determination, it's a best interest test. It's sort of a comparative fitness analysis that compares the two parents. There's not really a preference one way or the other. As a matter of fact, one thing that our legislature has chosen to do is to modify the custody statute to specifically state that the court shall order a custody arrangement that permits both parents to enjoy the maximum participation possible in the life of the child consistent with the factors that are set out in the statute. So the legislature has recently chosen to amend the statute to reflect that there is a preference for both parties being involved to the maximum extent possible.
Okay, and that new preference that they've put in there, though, that only applies to cases that are new cases that have come before the court after the enactment of that statute. Is that correct?
That is correct. However, it could impact cases in modifications once the court determines that the proper showing has been made to then perform a best interest analysis. Then this statute could come into effect in that as well. And that's kind of the next place that the conceptually what you've got to think about in child custody is once there's been an initial determination made, there's a heavier burden to come back and then change that arrangement in the future. But getting back to the initial custody determination, the Tennessee Code Annotated 36-6106 sets forth the factors that the court shall use to determine the initial custody determination. The statute provides that the courts to consider the location of the residences of the parents, the child's need for stability, and all other relevant factors. And then it sets out a list of 10 factors that the court's to apply to determine what the custody arrangement for the particular child or children at issue should be. Those factors, I'll just run through them real quick. Number one are the love, affection, and emotional ties existing between the parents or caregivers and the child. Number two, the disposition of the parents or caregivers to provide the child with food, clothing, medical care, education, and other necessary care, and the degree to which a parent or caregiver has been the primary caregiver. Number three, the importance of continuity in the child's life and the length of time the child's lived in a stable, satisfactory environment, provided that where there's a finding under a separate subsection here of child abuse, as defined in other Tennessee statutes, then the parent and the non-perpetrating parent or caregiver is relocated in order to flee that abuse, then the relocation shall not weigh against an award of custody. So, in other words, if someone flees in the middle of a custody determination and there's not an abuse situation, that's going to be a factor that would go against them. Mm-hmm. However, if there's an abuse situation, then that factor does not weigh against them in that situation. Number four is the stability of the family unit of the parents or caregivers. Number five is the mental and physical health of the parents or caregivers. So, if you had someone who was had a serious illness or something, obviously that would weigh against their ability to provide and take care of the children. So that's a factor that would weigh against them. The home, school, and community record of the child is the sixth factor that the court looks at. The seventh factor is the reasonable preference of the child, but that's if the child is 12 years age or older normally. However, the court can hear the preference of a younger child in the court's discretion and upon request, but the statute specifically states, kind of a common sense approach, that the preference of an older child is to be given more weight than the preference of a younger child. The eighth factor that the court applies to determine custody is evidence of physical or emotional abuse to the child, to the other parent, or any other person. There is a little bit more that goes into that in determining who was being abusive, and there's no need to go into that detail for purposes of our discussion. Number 9 is the character and behavior of any other person who resides in or frequents the home of a parent or caregiver, and the person's interactions with the child. And that's sort of a common sense factor as well. I mean, if you had a parent that's living with a known drug dealer, that's going to militate against them in a custody determination. Number 10 is each parent's or caregiver's past and potential for future performance of parenting responsibilities, including the willingness and ability of each of the parents and caregivers to facilitate and encourage a close continuing parent-child relationship between the child and both of the child's parents, consistent with the best interest of the child. And interestingly, the legislature has also chosen to put a gloss on that last factor, and that's the ability of the parents to work together. That's a new focus that the legislature has chosen to address, and as of May of this year, they've amended the statute to provide that in determining the willingness of each of the parents and caregivers to facilitate and encourage a close and continuing parent-child relationship between the child and both of the child's parents, the court shall consider the likelihood of each parent and caregiver to honor and facilitate court-ordered parenting arrangements and rights, and the court shall further consider any history of either parent or any caregiver denying parenting time to either parent in violation of a court order. So, in essence, if it's the first time that custody has been before the court, those are the factors that the court's going to look at. They're going to apply the facts that comes out in evidence before the court, and they're going to take those facts and evidence, apply those factors to it, and make an initial custody determination.
Okay, and generally a custody determination is going to be between the parents, the mother and the father.
Correct.
Because I know we get calls sometimes where it's a grandparent, an aunt, an uncle, or an older sibling trying to get custody of the children.
Absolutely, and in that situation, I mean, I could oversimplify it, but for purposes of our discussion, I would state that, with some exceptions where a parent may be dead or something, there is not a grandparent right to custody. There are, again, some exceptions that are probably beyond the scope of our discussion today. But in general, yes, I mean, we're talking about a comparative fitness analysis between two parents when we're talking about this statute.
Okay. And with this, as far as what courts are we talking about that are normally going to be hearing custody disputes?
Well, it could be before the juvenile court. We have one, of course, here in Shelby County. If the child is born out of wedlock, and juvenile court would apply the statute just like the circuit court or chancery court would in the case of a divorce. But if a child's born out of wedlock, the proper jurisdiction over that case is before the juvenile court. If we're looking at a custody determination that's being made as a part of a divorce or is being modified subsequent to a divorce, then either the circuit or chancery court, as the case may be, it's a luck by the draw sort of deal. They hold continuing exclusive jurisdiction, those courts, to rule upon any modification.
Okay. When we return, we'll continue our discussion about child custody. Please stay with us.